Hello, everyone. My name is Robert Romano, and I'm an assistant professor of sports management at St. John's University and also a practicing sports attorney. What I would like to briefly discuss with you today is the concept of intellectual property, or how intellectual property, or IP, plays a role in the sports industry. The first thing we need to do, however, is define what we mean by the concept of intellectual property. IP is typically defined as the legal system that protects intangible goods that have significant economic importance. So, under intellectual property law, owners are granted certain rights, certain exclusive rights to their intangible assets. Those intangible assets could be anything from music, literature, artistic works, inventions, symbols, all that kind of stuff. So, under IP, the owner is granted certain exclusive legal rights because these intangible assets have an economic value. Okay? So, under IP, there are typically four various types of intangible goods that have economic importance. And those are patents, copyrights, trademarks, and to a different extent and to a different way of thinking, what we call the right of publicity. All right, so patents. First off, patents. What is a patent? We've all heard of it, right? And you typically, I get a patent is an idea. No, ideas cannot be patented. All right, what patents are they are a set of exclusive rights granted to an inventor, and typically for a limited period of time, in exchange for that inventor to disclose to the public what that invention is. All right. So it's not patenting the idea or the concept; it's patenting what we call the blueprints. Okay. So think about it. The concept of an air conditioner, cooling a room, right? Air conditioning. The concept, the idea of wanting to be able to cool a room cannot be patented, but how you actually cool that room, the blueprints, the design, how Carrier or whatever company cools that room, that can be patented. Okay, so in patents are prevalent throughout sport, right? Think about it. Equipment, sports equipment. Most important, sports equipment can be patented, right? Helmets, how helmets are constructed, how they work or fight against concussions. Baseball gloves, turf, right? Various forms of turf. Right now we got the rubber pellets in the turf. That's patented. Cleats, those can be patented. The bottom design of that cleat. Even carbon fiber prosthetic legs, right? Prosthetic legs that are used to put on athletes, especially in the Paralympic Games. Those can be patented. What other things can we think of? The yellow first down line marker, patented. And also team colors. Right, team colors, you think about it. Well, how could a color be patented? Well, what you're patenting is not the color, but the formula and how you get to that color. Okay? So if you design something, you come up with the blueprints for something, you can protect it, that design, that blueprint, by filing it with the Patent Trademark Office down in Virginia. All right? So that's one type of intellectual property. The second type of intellectual property is what we all have heard of, is copyrights. Right, copyrights, again, it's a legal concept that gives the creator of original work exclusive rights to use it. Right? And so what do you copyright? What's typical things that could be copywritten? Books, poems, song lyrics, articles, PowerPoint presentations. Right? All these things can be copywritten. And we all heard it. We hear it during every major property sporting event, right? We hear and see the warnings, right? The federal football, any use of this telecast or any pictures, descriptions, or accounts of this game without the written consent of the NFL is prohibited, right? They're enforcing their copyright, right? So the games themselves can be copyrighted. And how do we make sure our copyright is protected? Well, one way, we see it all the time, that little C, right? Put that little C with the circle around it. But basically, anytime you create something, it already comes with a copyright. But again, if you want to protect it, you can send it down to the Copyright Office and make sure that it's stamped and protected. The third form of intellectual property are trademarks. All right, trademarks, or distinctive signs or indicators which identify that the product or service is exclusive to this brand. Okay. The Nike swoosh, right? The famous Nike swoosh. That's a trademark. The bitten apple for Apple, Coca-Cola, right? And trademarks are prevalent throughout sports, right? Most sports teams have to trademark their colors, right? Their colors, their emblems, their logos, right? The New York Yankees, that NY, that needs to be trademarked, right? So because you don't want somebody else using it without your permission and making money off it. All right. So think about that in the context of sports. Every logo that a team has to be protected, right? And every variation of that logo has to be protected. And then we'll take it a step further is that not only do you have to protect every variation, you also have to protect it on what goods you're going to put out there that people will buy. So if you're going to put that New York Yankee NY on baseball caps, well, you have to protect it on caps. You have to protect it on shirts. You have to protect it on shorts. You have to protect it on sweatshirts. All right, so they all need to be protected. So the extent of coverage is pretty significant. All right, now throw a question out to you all real quick. What do you think is the most protected trademark in the world? And give you a little hint, it is associated with sport. Take a second, think about it. What is the most protected trademark in the world? The Olympic rings. All right, the most protected trademark in the world. All right, so now we continuing on with our fourth type of intellectual property. And this is a little different than the three, the patents, the copyrights, and the trademarks. And the fourth one is what we call the right of publicity. All right, and the right of publicity is the rule that a person's name or likeness may not be used without that person's consent for commercial endeavors. All right, so nobody can capture your image and sell it to make money on it. Okay, and the right of publicity has two prongs to it. First part says that you, as an individual, can take your likeness and sell it to a third party for commercial profit. You have that right to do that. So if you want to capitalize on your image, you're more than welcome to do that. And the second part says you can stop somebody from capitalizing or commercializing your image without your consent. All right, so there's two parts to that right of publicity. All right, so there in a nutshell, our intellectual property in sport. We talked about four various types. Thank you for your time, and I wish you all the best. Thank you.